Yeah. I requested for the letter to be read because for me there's a fundamental constitutional issue that as a committee we should advert our minds to. It has nothing to do with the individual nominees. I would have preferred that this discussion took place in the absence so that it doesn't look like it is about them. But there's a fundamental constitutional issue that as a committee we should advert our minds to because I want it captured in the report. It's never come up before. I've been on the committee. We've vetted a number of Supreme Court judges. I believe that issue affects most of them, but it never came up. But I want to raise it today. One, the President said he is making the appointment pursuant to his powers under Article 144. Article 144 says, a Chief Justice shall be appointed by the President acting in consultation with the Council of State and with the approval of Parliament. The other Supreme Court judges shall be appointed by the President acting on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. The offices of Supreme Court judges are created under Article 128 of the Constitution. And this is what it says. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. The Chief Justice and not less than 9 other justices of the Supreme Court. Now, as we speak, we have 15 justices on the Supreme Court. We're told that one is retiring, but we have 15 justices of the Supreme Court. It means that we have 9 plus the Chief Justice making 10 and an additional 5, making it 15. This letter states that 2 of the 15 are about to retire. The President is seeking to make early arrangements to make sure that there's no vacuum when the 2 do retire. One has retired already, the other is about to retire. The legal issue that I'm raising before this committee, which should be captured in our report for discussion, is this. Whereas the Constitution in Article 144 says the President shall appoint the justices, there is nowhere in this Constitution that the President is given the power to increase the number beyond the 9 plus 1. Nowhere. And I challenge anybody in this room to show me any provision in this Constitution that says that even though Article 1281 says 9 plus Chief Justice at the minimum and you don't have an upper ceiling, that the person to decide that upper ceiling is the President. Who says the person to decide that upper ceiling is the President? Who? Show me which provision. That he can, anytime he feels like, and I'm not talking about this President, previous presidents have done that before. So it's not about this particular President. Any President, anybody should show me anywhere in this Constitution where power is given to the President to increase the number above 9 plus 1. No such power is given to the President. Now, we have had a practice where a President sits and as and when they feel like, they just write to us, I have appointed this person, process him for her to become, or he to become a member of the Supreme Court. No provision is made for the enhancement of the numbers. This is my position on the matter. Article 298 of the Constitution is clear on this matter as well. There's a provision, and I refer you to Article 298. It says that subject to the provisions of Chapter 25 of this Constitution, where on any matter, whether arising out of this Constitution or otherwise, there is no provision, where there is no provision on any matter arising out of this Constitution, express or by necessary implication of this Constitution, which deals with the matter that has arisen, Parliament shall, by an act of Parliament, not being inconsistent with any provision of this Constitution, provide for that matter to be dealt with. So, in the absence of an express provision on the specific issue on the upper ceiling, it is Parliament that should from time to time pass legislation setting the upper ceiling. Not just any president gets up and says, I want it to be 15, I want it to be 30. It has to be Parliament passing the legislation. It could be proposed by the president, fine, but Parliament has to pass that legislation. I have an example in the Indian Supreme Court. The Indian Constitution says the number is 7 for the Indian Supreme Court. Today, we have an Indian Supreme Court Number of Judges Act, and that places the number of judges at 33. Yeah, not exceeding 33. So each time they want to increase their number, they have to go to their Parliament. The Parliament will pass a legislation, increasing the number. Anybody who says I'm wrong and says that the president has a discretion, even though nothing is said about the president being the one to determine the number. He only says that he should appoint them. But it doesn't say he's the one to decide the upper ceiling. But assuming you even say that the president has the discretion, we all know that the exercise of discretionary power comes under Article 296. And again, the same mechanism of parliamentary approval of the number is provided for in 296. And 296 says that where in this Constitution or in any other law discretionary power is vested in any person or authority, where the person or authority is not a judge or other judicial officer, there shall be published by a constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this Constitution or that other law to govern the exercise of the discretionary power. So even if you say that, the president has the discretion, a discretionary power, the exercise of it is governed by Article 296. So the president ought to have brought a constitutional instrument to Parliament saying that I intend to place the upper limit of the membership of the Supreme Court at 15, even though the Constitution says that the Constitution minimum is 9 plus 1, 10. I intend to make it 15. And then this will be taken through the process of approval of constitutional instruments by Parliament. If 2/3 of the House says no, we don't accept it, then they have to remain at the number that they are. If 2/3 are not mobilized to block it, then we now have a law that places the upper limit of our Supreme Court at 15. And then we, as Parliament, can then process nominations to fill the vacancies. Barring that, I think that we have been doing an illegal thing, an unconstitutional thing. The president has been exercising the power without any foundation in the Constitution or any law that I know, and I want to raise it and have it captured that I object to the nominations on the basis of the fact that it is unconstitutional. It flies in the face of Article 128 of the Constitution, and it is not founded in Article 144 of the Constitution. It offends the discretionary power provisions of Article 296. It doesn't satisfy the Parliament's powers to fill in voids under Article 298 of the Constitution. I don't know if you want to continue with this exercise, but to tell you the truth, we've been doing the wrong thing. Somebody will say that it has been happening. The same Supreme Court that they are seeking to go and sit has said that the fact that we've been violating the Constitution doesn't mean that one day when we wake up and realize that we have been violating it, we should sit up and correct our mistakes. I think this is a major constitutional, issue, and as a committee, I think we don't have the capacity to deal with this. We should capture it in our report and refer it back to plenary for consideration. Thank you, Madam Chairperson.
Thank you very much, Honorable. I think your point is well made, but we have a platform where we can consider that. The reference was made to us to proceed and vet the nominee. That was the directive, yes. So what we will have to proceed, and when we have a platform at the chamber during the debate, I think these issues can be well placed, and then we'll take a decision on that. So we're going to proceed.
Madam, with all due respect, before you make that determination, I think it's only fair that you allow members to have a bite on this matter, because he's raised a very important matter that I believe not only him would like to comment, but other members would like to comment on. So please allow others to make a comment on this matter before you finally make a determination. Thank you.
Thank you, Madam Chairperson. I want to commend our colleague Honorable Mahama Ayariga for this foresight and then this legal expose that he has made this morning. I think it's a wonderful submission. It's never too late to learn. So saying, I think that this August House, the law house, we should deepen democracy. There are many avenues in the Constitution that need practice and convention. And I think what we have observed now is an oversight on the part of all of us since 1993 that we started operating this Constitution. The issue we have raised is so fundamental and germane that I thought that what Chairperson could have done was to say, okay, this is a preliminary objection to the process that we are going to undertake this morning. Let's vacate it and go back to the chamber and raise this issue, that we think that we have been exercising this function in breach of the Constitution, and therefore we want guidance on this issue from the rest of the members of the August House, and then we will take a decision that we are not guided and we can know our left and right on this matter. But I don't think that it is fair to say that even though the objection raised is valid, let's continue to vet the nominees, and then later on we go to the chamber, then we can raise the issue. That will be an exercise in futility. And if what we have been doing in the past is an illegality, why do we continue with the illegality if our attention has been drawn to it by Honorable Mahama Ayariga? So with the greatest respect to Madam Chairperson and my colleagues, I think that this is a matter that we should suspend the proceedings, the vetting today, and then remit this issue to the chamber, and we debate it and take a decision, and then we can go ahead to vet the nominees. And as Honorable Mahama Ayariga observed, this objection doesn't have any prejudice on the nominees. We've read their CVs and they are very well qualified and efficient to go to the Supreme Court. Like he said earlier, I thought that if we were minded, the nominee didn't need to be here before we raise this to expose it to public view. But I want to submit humbly that I think that we should truncate the proceedings, then refer the matter back to the chamber, and then have an open debate and take a decision. That is the only way Ghana can respect this parliament as having an oversight and then deepening democracy in our dispensation. Thank you.
So, Madam Chair and colleagues, I think that this is not the first time we are engaging in a vetting process. You can say that this is unique in its form and substance, and we all concede to that. What I know as a practice is anytime we have a nominee before us and any of us feel strongly about a matter, that sentiment is communicated ahead of time. Of course, you're not bound to communicate your sentiment before coming here. I mean, in times past where you feel strongly about a nominee, you say, okay, this one, because of such and such reason, we are not participating. I think all the engagement we've had, this never came up. This comes out as a surprise. However, we all have our views in terms of the interpretation of the Constitution. So one person's interpretation cannot be an authority. And we are not clothed with the powers to interpret the Constitution. That is, I respect the Honorable Mahama Ayariga. He's a senior lawyer. We all respect him. But his interpretation of the Constitution cannot be an authority. Our job is simple. We have been mandated by the Speaker based on appropriate and an official referral for us to consider a nominee before us. The nominee is yet to be heard. Afterwards, we will generate a report for plenary. And if you heard, I heard my colleague, the Honorable Ayariga, so well when he started. He introduces his matter by saying that he wants what he's saying to be captured as part of the report. And this cannot bar us from doing our mandate, mandated by law and also by Constitution. So, Madam Speaker, I think for anybody to suggest that we should truncate the process and therefore wait for a determination of what the law says before we proceed, it's neither here nor there. And my senior colleagues knows that this is suggestion. It's a wild one, for want of a better expression. It's a wild one. And as the minority leader said, we should hear other views. That is democratic environment, yes. But ultimately, we must proceed and do the vetting. And then in the course of generating the report, all these dissenting views can be captured in the report for plenary to consider and for decision to be taken, whether to approve or not to approve. But to say that we should disrespect the Speaker and say that, oh, the Speaker himself was wrong by referring the matter to us. Senior, I think you are wrong. And we should allow the process to start and then the report to be generated.
Yes, I also want to speak in support of the position canvassed by Honorable Mahama Ayariga. So this is the position. I would start even by saying that there's currently no vacancy at the Supreme Court of which somebody is trying to fill. There's no vacancy. A vacancy, one of the vacancies would exist a few weeks after the president leaves office, and he's in a hurry to fill that vacancy in the future, even before we get to that place. But the substantive issue is the Mahama. You said one of them retires close to the end of the year. He raises an issue that we must all take on board, and he said that this is not about the current president. That presidents over the period have been exercising a power they probably don't have, because we have also pointed out that when powers are given to people in law in our country, we are expected to exercise that power without any caprice. That is, you exercise good judgment. So on what basis has presidents been lifting the numbers consistently beyond the 9+1? Is it not time that Parliament makes a law to actually set it? The worst one, Madam Chairman, is that the Chief Justice herself has entered the fray of trying to apportion to herself a power she didn't have, by actually saying that she's justifying the increase of numbers of the Supreme Court. That is completely self-serving to start with, because she has no that power. How do you determine why would the Supreme Court justices be the one to determine how many people? Parliament doesn't determine how many seats are in Parliament. It is not Parliament that just wakes up and does that. Other people do that. So it's common knowledge that, I mean, of course, I'm not a lawyer. You don't become a judge and a jury in your own court. So how the Chief Justice got to a point where she is the one justifying increasing the limit of the numbers at the Supreme Court, I mean, it flies in the face of justice itself. And that is why the call by Honorable Ayariga that beyond even today, there should be a clear effort by the states to determine how many Supreme Court judges do we have. The last time I listened to the Chief Justice, she says that they have a lot of cases pending at the Supreme Court. So the question is, so if you finish the case, will you discharge some of the judges as well? Assuming you finish the backlog, what happens to the judges? Because it's not cheap. A lot of people in this country are concerned about how much is spent to maintain a member of parliament.
they've forgotten that that is nothing close to maintaining a Supreme Court judge. It is nothing close. It's far bigger. So I think the call cannot be wished away. I would go as far as saying that if you don't know something and you are doing it and you are being caught, you can say that, okay, well, you've been notified. You will say that, oh, I didn't know about. But today we've been duly notified that we have been doing something which is not clear in the Constitution. So are we supposed to say that even as our attention has been drawn, we should continue, or we should do what we're saying, that maybe we pause and then see whether there's a way out. In fact, this government have made bills in Parliament and under certificate of urgency, and we've done it in a day before. Nothing stops them from bringing a bill tomorrow, or when in fact we will forced to reconvene. They can bring a bill that we should start a CI, a new CI, to bring the city to work, and then we'll deal with it. So I'm in support of the position canvassed by Honorable Ayariga. Thank you. Please.
Thank you, Chair. I'm happy that the honorable member Ayariga raised this point. I always say that there is a law called the Miles Law. The law of Miles says that where you stand depends on where you sit. I'm very happy that he quoted that this wrongdoing didn't start just now. It started long ago when he was still a lawyer. What I want us to know as a country is that our current constitutional arrangement is what we are obeying. Beyond that, there's nothing we can do. I don't know why people even sometimes compare our Supreme Court to the Supreme Court of America and India. For example, if you take the Supreme Court of America, they have 9 justices of the Supreme Court. The jurisdiction of Ghana's Supreme Court is wider than any of them. This is very evident in Articles 130, 131, 132, and 133 of our Constitution. I mean, it's clear. It has placed a lot of responsibility on our Supreme Court. And so, while the Supreme Court is giving a minimum number, the Supreme Court doesn't give any maximum number. And to that effect, we can't tie our hands to that effect. Even if you relate to Article 146 of our Constitution, the Supreme Court justices of our Supreme Court, they retire at age 70. In America, it doesn't happen that way. Any judge in America will be at post. However, you can't say that to Ghana. So please, let us hold the fact that our current constitutional arrangement needs amendments. If we hold that view, then we can move on. But for us to state it when it is fit, when it suits us, then we fit it. When it doesn't, then we say no. Please. Thank you. Point of correction. Yes, Madam Chair.
I think you did reference to you.
So let me go. First and foremost, I did not mention the U.S. Supreme Court. And I did so consciously. I mentioned India because the jurisdiction of the Indian Supreme Court is the same as the jurisdiction of the Ghanaian Supreme Court. The Indian Supreme Court has original jurisdiction to incorporate their constitution and laws, has appellate jurisdiction to hear appeal from all their high courts, okay, and has supervisory jurisdiction in the same manner that our Supreme Court has. So I was careful in drawing the parallels. I am informed by what when I'm doing something, I'm well informed. So I know the jurisdiction of the Indian Supreme Court very well. India has a population close to 1 billion, 1.4 billion. Divide 1.4 billion by 33, and that gives you the ratio of the population to their Supreme Court judges. Okay? In any case, I have not said that the 50 is too much. I have not said that. I have not said that. Yes, I didn't say that. Listen carefully. Listen carefully too. Listen. No, we're not enough for anything. No, please. I have not said that. I have never said that the 15 is too much. I didn't say that. Others have argued that. On radio people have argued that. On television people have argued that. But I said that even if you are adding one to the 10, logically, it should be backed by law. Either a constitutional instrument or an act of parliament. That is all that I have said. And as for when it suits, it has never suited me to obstruct somebody from becoming a Supreme Court judge. Is that okay? But our duty here as gatekeepers of our Constitution is to do our job without fear or favor. There are people that have been presented here that I like. I've read their writings, I've read their judgments. I know their family members. Some of them went to schools that I went to, and I know that by virtue of the schools they went to, they are competent and etc. But because I went to those same schools, I also know that I have a duty to my Constitution, and I must interpret it properly. And if anybody is a president and I'm to guide that person, I will show the person how to do the work properly. So please, we are not here doing partisan work. I said every president that I have known since the number was increased beyond 10 has violated this, and we parliamentarians have condoned it by allowing it to pass without ever questioning it.
Thank you very much. I'm giving the last opportunity to Honorable Boy. Let us speak. Thank you so much, Honorable Chair. Majority Chief Whip said something that Speaker will be disrespecting the Speaker if we went ahead. I'm quoting you. And I say that Speaker is a legal man. He'd be very happy if we pointed out to him if he had gone wrong. The nominee, just by seeing her, I really like her. But that shouldn't be the yardstick. Let's do what is right. We are the gatekeepers. If, like the issue Honorable Ayariga raised, we've been doing the wrong thing and we do it right, there's nothing wrong with it. So I think I agree with him. Thank you.
Thank you very much. But I think we should really end this.
Honorable Deputy, please. Thank you very much, Madam Chair. I would like to get some education here. Maybe the ordinary English that we've been taught in schools are different from the legal languages. Honorable Ayariga said that the Constitution says that minimum of 9, or at least 9. The error to the ordinary English students to the ordinary English students, if you say at least 9, and you don't bring at most, it means you should make sure that at any point they don't have less than 9. But depending on the situations around, the cases that you have, you may jack it up. So as of now, if the little English as an English student I'm talking about, I'm not law because I'm not a law student, then I will appeal that then it means, as he said, there's an error in the Constitution. But it shouldn't be managed as if there is a law has been broken. But then moving forward, we look for a platform to rectify this, that we did not have any maximum or given minimum. So then I appeal that let's clear what we have today, having in mind that the English word may be the same as law or different from law. We manage this one, we get to the floor of Parliament, the chamber, and then we analyze this. If we need to push it to the next level, where they're going to be an interpretation or they're going to be the constitutional issues that we will go through in Parliament, we do that. I will appeal that to summon everybody here before we give him the light It's no fault of any of us. Assuming the light is a white light means it contains all the colors of light. So whether you take it to Supreme Court, you take it to Supreme Light, it is still the white light. So I appeal that, yes, we've been educated. Yes, the new students among us, we are not given at most, we are given at least. So that we manage this today. And then going forward, we see how well we could bring the highest caveat so that it wouldn't be like if whoever is in chair wants to appoint 300 Supreme Court judges, it becomes on and on and on, or they get to some. We need to start from somewhere. But I want to appeal that to start from today, it's a bit too late as of now. So let's get it done. And then we, as we are educated, we do the needful. Thank you very much.
I'm giving a chance to everyone because I see the other hand showing better.
Thank you. I think the honorable member didn't get it right, if I may so say. It's not so much about the limit or the list. It's about how the discretionary power is exercised. That is the point the honorable member Ayariga said, and that is what the majority of us here have supported. So it is not about the grammar of it, but it is about how the power is exercised. That we've been doing the wrong things, and if the Constitution says that if we are doing the wrong thing and your attention is drawn to it, you have the room enough to go back and correct yourself and work within the Constitution. So that is where we are heading towards. And also, Madam Chair, I also want to say that it's unfortunate that the chief whip is okay, so he gets in now. Because the comments are here and the public is having privy to what we are discussing here. It will not be fair to place on record, as you did, that the previous engagements will not raise issues of concerns like the one that Honorable Ayariga raised. I am not so much aware, maybe it happened on my blind side as a member, of the engagements on this particular appointment or the vetting. If maybe it was a matter of leadership discussion, that is fine. But it will not be fair to say that we've had several engagements and these issues have not come up. I think that should be corrected if that is not the case. Thank you.
Again, I hear my name loud and clear. I thought, Madam Chair, I mentioned your name. Okay, so maybe I should simplify what I said. And if I meant to convey any misgivings, forgive me. What I meant to say is that fundamentally, is there any provision in this Constitution that has been flouted? Fundamental question. And the answer is no. No. So if you are claiming that there is any specific provision in this Constitution that has been flouted, point it out to us. Even if it is the case, if you are even able to do that, that will reflect in our reports. That will reflect in our report. Nothing should stop us from proceeding to consider the nominees. And at this juncture, without adding more, Madam Chair, I invite you, if you allow me to be the first person to start my questions. I have my questions ready so that I can start. Yes. Madam Chairperson. Madam Chairperson. Yes, I intend to move a motion. But I intend to move a motion. No, I haven't given you the floor. Thank you very much. I think we have had a fair discussion on these issues, and it's now with the leadership. Yes. So I'm going to ask Honorable Board to make the Chair. Thank you very much. I simply want to make this point that what we are discussing here has precedent, and it's very, very important. And I want this committee to understand a issue of how
at 919 the petroleum law was passed. I remember that we had brought the bill to the Energy Committee. Honorable Jogati had raised very fundamental issues relating to the Constitution, which is always our guide. And he drew our attention at the time that we needed to make sure that there was a regulator, because that resource is a natural resource, and the Constitution requires that we should have a regulator. That is how we came back. We suspended the passage of that law, went back to bring the Petroleum Commission Act, passed the Petroleum Commission Act, before we went to pass at 919. Now the point that has been raised here is very important. The Honorable Ayariga has drawn our attention to our guide, which is the Constitution. We are guided by the Constitution in everything we do. And the point is made is that there is a limit, but there is no upper limit. And because of that, there has been this discretionary power being developed, and we have an opportunity to address that. I think this point has been made. But for this committee to take this very important point, which really is at the heart of the Constitution, back to the Premier and the Speaker, it's something the Speaker and the Premier will be very happy with. The Speaker will not be unhappy at all. It is also important we know that this appointment committee has the authority to address this issue, and no other committee can. It is this appointment committee that must go to the House with this very important lacuna to get the House to address it. And so this point that has been, we agree. So the point that has been brought by the learned Honorable Ayariga must not be something we wash away. This committee must make a decisive decision. A decisive decision whether to go forward or not. And so, Chair, it is in your hand. We need to make that decision. And so, I think clearly,
Madam Chair, the letter from the President read appointment of justices of the Supreme Court. And I read the first two paragraphs, and you understand why there is the need for us to pay attention to what Honorable Ayariga is saying. So I hope this finds you in good health and spirits. As a result of pending and projected vacancies on the Supreme Court, occasioned by the retirement of Mr. Justice Ni Ashikote on 2nd October 2023, and pending retirement of Justice Mariama Owusu on the 18th November 2024. Can we please 2024, respectively. The Judicial Council advised me on 24th May 2024 by letter under the hand of its chairperson, Chief Justice Gertrude Tokono, of its nominations for my appointment to the court of their replacement in accordance with Article 114(2) of the Constitution of the Republic. Then it goes on in paragraph 2 to say that in order to achieve the full current complement of the justice of the court of the next legal year, I have decided to appoint the Supreme Court as advised by so and so. My question is, and Madam Chairperson, my question here is, it says, in order to achieve the full current complement of the justices of the court for the next legal year, who established the full complement? And what is the full complement? The Constitution placed a minimum number, 10, Chief Justice and 9 others. Now we are talking of the full complement, and the letter in second paragraph says, in order to achieve the full current complement of the justices of the court for the next legal year. Now, what is the complement? Who established that? Is it a matter of the Constitution? Is it only to the President to appoint to establish the complement, or is it for Parliament or a law to establish that complement? And that is why the argument coming from Honorable Mahama Ayariga cannot be washed away. There are critical questions. Look, I believe in continuous improvement of our governance. You can't get it right from day one. But let it be that at any point in time, we sitting here as elected representative of the people, we must add value to our democracy every single day. Now we are seizing the opportunity to add value to our democracy, to make a determination that all presidents probably may have eluded them. And someone has pointed out that something is wrong. I think it's only right that we listen to him, take an action, and then do this. Madam, on the basis of that, I move that this motion coming from Honorable Ayariga be taken, and that we should vote on that matter. Thank you.
First of all, Madam Chair, I think my respected leader should get his facts right. I second respect to him. The Honorable Ayariga didn't move any motion. We don't have any motion here. What he said, please, when you speak, you should listen to us too. He says, and he paraphrases, amongst other things, says that he wants this to be captured in the report of the appointment committee. The chairperson has not entertained any report. We are going to entertain a report. So if it is the case that we want to come by proper motion for us to take a decision on this, then we should take a decision. But even that would be wrong. Madam Chair, that would be wrong. Parliament cannot be stopped from performing its statutory duties. And one of our statutory duties as an extension of Parliament, an appointment committee to consider nomination for His Excellency the President. What are we doing? We are only to vet and to report to plenary for decisions to be taken. We are not determining whether we are going to take a matter under certificate of agency which will be determined by a committee. No. This is vetting. Madam Chair, I invite you. I am ready for us to start.
Thank you very much. Thank you very much. Honorable members, I think I've given a fair chance to each member to make his or her point. Here we are. This is a constitutional issue being raised out here. It is the Supreme Court that determines the interpretation. Honorable member, please give me the opportunity to also speak, because I've given you adequate time to do that. Yes. So, you have made your point. Who interprets the constitutional verge of this particular thing? So, as said by Honorable Ayariga, it should be captured in our report, and we take it at plenary. And I also want to move that we move ahead, because you see, when the letter came, Mr. Speaker had a look at it, came to the floor of Parliament, and then read the letter to the hearing of members present. And Mr. Speaker referred it to this committee to proceed and vet our nominees. At this juncture, I think we have to just move on and do what is being required of us, the mandate that has been given to us, and we move ahead. We have an appropriate forum where we can address this issue. I think we have been given a referral, and our core mandate is to ensure that we go ahead and do what is needful. Thank you very much. And so I'm going to start again.
With indulgence. Committees of Parliament have the right to organize their meetings in the ways according to the standing orders. Madam Chair, indeed, we have actually convened committee meetings and have taken decisions at those committees not to entertain the subject matter before the committee. So there's nothing wrong if Honorable Ayariga is making a request. Ask the manager, move a motion. So allow him to move his motion. Yes. No orders are clear. Order 267 says that only members of the committee may vote or move a motion at meetings of the committee.
So I have raised an issue. You have allowed everybody to chew on the issue, and then announcing on the basis of the deliberations that are taking place. And let me correct you, if you have forgotten, I was sitting there when Speaker read the letter, and in referring the letter, these legal arguments that I'm raising, he raised them. Mr. Speaker drew attention to a long-standing debate as to whether or not we don't need a legislation to determine an upper ceiling. They said that he as Speaker cannot, but that he's referring it to us as a committee, and that we should go and decide what to do. So I move that we have raised the issue, we've debated. I move that we end proceedings and refer the matter back to plenary for consideration.
Honorable member, I think that we are not being fair. No, I'm not going to allow that. I'm going. No, please. Once you are there, I have not given you the opportunity. You also defend it. But I'm also making my point. Yes, my point is that we have been given a mandate. We are going to proceed because it's also not fair that you invite your nominees. You can't. Yes. Let's deal with the main